Normally, a person becomes their own guardian when they turn 18. And sometimes a person is unable to assume that role, right? They have a cognitive disability, or are unable to make important decisions about their healthcare and their personal, well-being. And it's advisable, necessary in some cases, to have someone make those decisions for them. Once they turn 18, mom and dad typically remain the child's guardians. And that tends to work really well. Now, sometimes people have disease that sets on later in life, dementia, Alzheimer's, those sorts of things, and are, again, unable to continue making their own decisions. And again, it's a situation where we would work with the family to have a guardian appointed. The types of families that I'm looking to work with are families where there's not really any debate about whether a guardianship is necessary. So we've got a person with a pretty severe disability, or a person with pretty advanced dementia, or something like that. And then also a situation where the prospective guardian is also pretty clear. The non-contested adult guardianship planning process starts typically with a phone call from someone saying, I've got a 17-year-old that's going to be turning 18 here pretty soon. I need to be his guardian or her guardian. The first thing we talk about is what can the individual that we're looking to set up a guardianship for do, right? Where are their limitations? Because the court really needs to see evidence of some pretty profound limitations. And once we're there, we put the petition together. Normally we get letters from healthcare providers and other supporting documentation, and we file it with the court. And under Iowa law, a hearing is required, and then we get an appointment of a guardian. I have done lots and lots of non-contested adult guardianships. As a matter of fact, I've been doing this as long as I've been practicing law. It's important to use an attorney because, again, this is a complicated process. I don't know that it's even possible to do this without an attorney. And as a matter of fact, normally multiple attorneys are involved. Under Iowa law, a protected person, a person nominated for a guardianship, is entitled to have their own separate representation. One of the things that I have been able to do through my experience in this area is to develop a process that allows us pretty reliably to get the protected party's attorney appointed at county expense, so mom and dad don't have to pay for two attorneys, which is really handy. I think our clients hire us to be their representation for a wide variety of reasons, but the biggest one, I think, is authenticity. We limit the number of clients we take in on a monthly basis because we want to spend the adequate amount of time with each client to make sure that we really understand you, we understand your circumstances, and we're not shipping out the same set of documents for every client, but it's highly personalized. The other thing that I think a lot of clients really enjoy is the fact that we're very educationally focused. We want you as a client to be empowered to understand what we're doing and why we're doing it. I don't adopt a prescriptive approach. I'm not here to tell you what you need. I'm here to help you understand exactly what the options are to achieve the goals that you have. I think our current and past clients would both agree that they had an exemplary experience. I think that they would genuinely say that they were met with caring and compassion, that they were heard and listened to, and they achieved exemplary results. Client communication is the most important thing, in my opinion, and that's why I work very hard to keep the channels of communication open. My goal is to return an email inquiry within 24 hours. I try very hard to return telephone calls the same day that I receive them, because I want you to know that I am listening to what you're saying, I'm working on your case, and I'm sensitive to your concerns. We are a very small firm, and we're a small firm by design. When I was in law school, I worked for a very, very small law firm. And my boss had been in the practice of law for longer than I've been alive. And so she had developed these rich relationships with clients, sometimes going across multiple generations, 2 and 3 generations of family members. And I was really blown away by the fact that she was able to do that. And it wasn't just a transaction; it wasn't a name or a file or a dollar amount. The goal when I established this firm was to recreate that experience and to be able to develop those deep, meaningful relationships with clients. So I will not hand your case off to another lawyer because I'm the only lawyer here. I feel really strongly about developing that relationship between the attorney and the client. Now, that being said, I don't hesitate to say if I feel like we're not a good match, if it's not a type of matter that I feel totally comfortable handling, or I feel like you may benefit from another lawyer better, I will certainly refer you to another lawyer. But once we've signed the agreement, I'm going to be doing the work on your case. The first thing we're going to do when we meet to talk about a non-contested adult guardianship is we're going to talk about the person that we're looking for guardianship for. Unfortunately, this tends to be a little bit of a difficult conversation. In the world of special education, we talk about abilities, right? What can an individual do? Unfortunately, the court focuses on limitations. What can't a person do? And so I guess I always caution my prospective clients that we're going to be talking about limitations. We're going to be talking about the things that you wish your child could do but can't. And so to be prepared for sort of that heavy lifting, that hard conversation, because we're going to have to show those things to the court.